Welcome to the Masterclass. You're ready to future-proof your ideas? Are you ready to stop competitor theft? It seems like you guys are not ready, so you can just go home. I need energy, guys. I need energy. Are you ready to future-proof your ideas? Are you ready to stop competitor theft? Are you ready to do the third thing that I can't remember? Awesome! welcome to I Have. My name is Nancy Ukuru. I will be your host, your MC, your CEO, whatever you want to call me, I am that. If you need directions, I'm ready to help, right? Who's been to I Have before today? Awesome, so we have a total of 2 people. So that means I get to brag about the work we do. We are an ecosystem enabler. And so what that means is we have focus areas, 3 of them: the creative industry, we have the education industry, and finally we have people in the health industry, and anyone in those 3 ecosystems gets support from us. This looks like accelerators and incubators, co-working spaces, podcast suites, editing suites, and so much more. Has anybody started a startup here? Yay! For the 2 people. Is there any creator in the house? Yes, the same person. Are there any innovators in the house? My person, that's the one I'm giving candy to today. So yeah, those are the kinds of people you support, and this event are the kind of setup we have to make sure you guys are supported, even if you're not necessarily a member of IHAM. So, first things first, I need you guys to move closer to me. Please move to the seat to the front. At the end of the day, it's a networking event, so you have to know your neighbor. Please move to the seat to the front. I'm Ken, and at the end of the day, we have to ask you to come to the front. Kindly move to the front. And as you come to the front, guys, I need affirmation. Do I look like my photo? Oh my God, they said no. I'm not offended. I definitely want to build points from you. Chayake, so so this is what we're here to do, and we want to kickstart it. And so this is the program for the day. Ideally, we should have arrived at 4. 4:30, we would have started the welcome, safeguarding, briefing, the icebreakers, and then we get into the real reason you're here today. Master Chorode, an advocate of the High Court, Kenya, will be taking you to the fundamentals of IP and practical strategies. After that, we'll get into a Q&A and an IP problem clinic, and then closing remarks, and that's when you get your tea after the closing remarks. So, ideally, our facility manager, Mr. Joseph Okono, would have done the safeguarding briefing, but because of the nature of the work, there is a fire somewhere that he has to put out. So I will be your facility manager today. Let's do this together. Let's find out together. So have a seat as I guide you on security and the safeguarding brief. And it's very, very intuitive. So number 1, let's be respectful. Let's treat everyone with dignity, not only the people inside the space, anybody interacting outside. Let's be inclusive. So if you see anybody struggling, let's ensure that their voices are heard. Let's prevent them from harm or any exploitation. It is everybody's responsibility. So yes, when you're here, please use inclusive language and maintain professional boundaries. Many of us are meeting here today for the first time. So let's take care of each other in that way. And then seek consent before taking any photo, quote, or recording, right? We asked for your consent before coming here, and we do have consent there saying that we will be doing photography, but if you don't want your photos being used on our platforms, please let us know and we'll take care of you. And similarly, if you're taking any content for social media platforms. Make sure your people are giving you consent. Always explain the purpose of any information you're collecting or sharing, and then respect people's choice to opt out, and then keep all personal data and stories confidential. So, if you see or experience any harm, it's very easy. Safeguarding at CC Hub Africa. That's the email if it's something long and you want to, reach out to them later. But you can take a photo of this and keep the number in case of any problems. That's our safeguarding officer. She will be able to help you if you feel or see any safeguarding risks, and we will take everything seriously. Finally, we have CCTV cameras everywhere. So yeah, we all know you're here. The security guys know you're here. And then seek assistance from the fire marshal. I am a fire marshal. Trust me. I am a first aider as well. So if anybody falls, I'll take care of you. Our fire exit is here. So in case of any fire, please exit from there. And then a quick checklist in case of fire. Evacuate immediately when you hear the alarm. Use the stairs, these stairs, do not use the lift. Stay calm, follow instructions, don't ignore the alarm, don't stop to collect any personal items, and don't block exits. So, drinking water was available at the back. We'll take care of you, don't worry. You can take any phone calls from outside there. The washrooms are on this direction, so you'll just stand right. Both the ladies and the gents are there. Anybody with special needs in the aerobic showers are on the ground floor. There is a prayer room for anybody who's need to pray. And then the smoking zone is at the very entrance of IHub. And that's it, thank you. So we're doing a Q&A. Where is the fire exit? Not there, come on, it's here. It's this way, okay? I got you, you're not listening, okay. Number 2, if you saw a fire, do you carry your personal items or do you leave them here? Shout, guys, it's the evening, you can shout. So do you carry your personal items or do you leave them here, yes or no? Yeah. You leave them, perfect. Thank you so much for giving me attention. And so now, I want to test you guys. I want to see how much you know about this ID things before we start, just to get a feel of the room. Are you familiar with the put a finger down game? Can you lead it? I'm kidding. So, I need you guys to put your hand up. Awesome. Everybody hand up. Right. So, if you have done the thing, you put your finger down. If you've not done it, you leave your finger up, right? The person who has a fist at the end of this, you're in trouble, but don't worry, it's a safe space. That's why Mercy is here. She's going to take care of you. Let's get into it. Let's try with this, and I hope you've gotten the instructions. So put your finger down if you've started actively marketing your brand name on social media or other platforms before checking if it was already trademarked. You just opened an IG page and you're like, that's me. That's my name. No fingers down, it's giving IP experts, okay? So all of you people starting your pages and your websites, before starting your website to check for trademark. Are you guys like better than me? Because I didn't. Okay, put your finger down if you've ever used a photo, music, or a graphic design that you found online for your business or marketing without verifying if you had the right commercial license. So you just had a fire song and you said, as a matter of fact, that's my theme song. That's me. Nobody's second finger is, oh, I see you and I made the same mistake. Put your finger down if you have ever used an NDA. Wow, how did you make NDAs? Where did they come from? I really thought only lawyers could do that. How do you smart people here? Put your finger down if you don't know what a trademark or a patent or a copyright is. If you've just been guessing your way through this, if you just be like, it's copyrighted, whatever that is. Oh, some people you just have all of their fingers up. I'm trying to be like you. Put your finger down if you've allowed somebody to use your product or brand trust instead of a formal written licensing agreement. There's some people whose whole hands are under. Kuna zenye ziko ground floor. Somebody's hands are in ground floor, and all the fingers are down. Did you trust somebody to use your brand and like, listen, you look like a good guy? Okay, fair. I mean, I guess that's why we're here. Thank you guys for participating. It's interesting to know that actually most of you are familiar with IP and trademarking and copyright. So thank you for participating, but my time is up. I want to invite to the floor Ms. Mercy Cheredi. She'll be the one who will be taking us through this session. She'll be the one to give us all the IP secrets. She'll be the one who will help us attract investors. So with a round of applause, let's welcome Ms. Mercy Cheredi. You can do better. Let's go. Thank you, Mercy. Karibu sana. Here's your microphone.
Thank you. I wasn't expecting the round of applause. But anyway, thank you. My name is Mercy Cheredi. It's the double C. How many of us did physics? How many of us? Physics. So what equals MC squared? What did you get in physics? Maybe I should have started with that. How many of us did physics? What equals MC squared? E. What is E?
Energy.
So if E is energy and my initials are MC squared, what am I bringing today? What am I bringing today? Energy. Thank you. Thank you for the positive affirmation. So, yeah, I think we can start. So our topic today is future-proofing your idea, whatever new invention you have. So the idea towards today's masterclass is basically to stop competitor theft, attract investors, and basically owning your own assets. So who are we? Nancy there got her bragging rights through iHub. I'll get our own. So CM Advocates, we are top tier law firm headquartered in Nairobi, Kenya. We have 2 branches in Diani and Mombasa. We also have a regional presence in Ethiopia, Nigeria, South Sudan, Tanzania, Uganda, and Rwanda, also Zambia. So we have a managing partner, 5 partners, and over 60 professionals. These professionals are very vast, some of them are there. We specialize in business law, employment law, real estate, dispute resolution, family law, and debt recovery. So our main offices are at I&M House. Let's get into the masterclass. So the purpose of this masterclass is to protect and secure innovation. There was a startup somewhere. Have you registered your IP rights? Any of them? This masterclass is for you and for any other person. And then to create measurable business value, ideally for the persons who have registered their IP rights, you have to learn how to commercialize whatever you already have, and then to turn intellectual property into revenue. That will be through commercialization and to reduce legal risk. For the people who have been using songs which have not been licensed, I'll teach you how to reduce whatever, not to evade the law, but to be smart about it. Okay. So what is IP? For the person who has registered IP, I did get the hands. So basically, IP is basically the creations of the mind. Whatever you create is basically protected as a legal asset. So there's a statistic which was done in 2014, and it revealed that 53% of the innovators had not registered their IP rights. Of the 53 minus 100 is, that's 47. Of the 47, only 3% had commercialized their IP rights. That means that 97% of innovators in Kenya basically do not even use the IP rights in the sense of revenue. So ideally, you'll be asking yourself, why is IP important? We look at the Facebook story. How many of you are aware of it? The Facebook story, it was big. Okay, how many of us are millennials? Because for the millennials in the house, I'm sure you know what Facebook is. Now it's still Facebook actually. Let me not repeat my age. So Facebook began in 2004 as Mark's Dome project, but we both know that, not both, okay. For the Gen Zs, I'm sorry, this presentation is majorly based from a millennial's perspective. So let's proceed. So the twins had earlier on recruited Mark to code their own social media network, which will be called the Harvard Connection. It was rebranded to Connect You. So when Mark launched Facebook, there were conflicts on the ownership, execution, and competitive advantage of whatever Mark had. The lawsuit ended in a $65 million settlement, demonstrating how unclear agreements and the lack of intellectual property protection can escalate into legal battles. So ideally, we can pick 3 things from the Facebook story. First of all, the twins contracted Mark without an agreement. That would ideally mean that the innovation doesn't have any legal basis or even any legal structure of ownership. The second thing we can pick from this story is that execution must include protection. Had the twins protected whatever they had, ideally, Mark would not have gotten even named or even gotten a way of leveraging whatever information he got through being recruited by the twins. The third will be that informal deals create risk. You can see that the deal led to a $65 million settlement. So this is the cycle of leveraging intellectual property law. The first will be to identify what type of intellectual property you deem to protect. I'm not sure about the sectors which you have. Can I pick randomly? Do I have consent? Consent is a must. We can start with you. Do you have a brand? Do you have anything which you would like to protect via IP?
Yeah.
Which type of product will it be?
It's a climate innovation.
Sorry?
It's an innovation in climate.
An innovation in climate.
Yeah.
Is it something new?
Yes.
New. Did you get inspiration from anything?
Yes, taking from different ideas and then putting it together.
So ideally that will be a utility model. So I'm getting that it's not protected. So I'm the first and last person you're telling that idea to.
Yeah.
Until it's protected. And then the second thing is to protect, just as you've spoken about, and to monetize. Ideally, after protection, investors always look for protection. No investor will look at you when you've not even done your legal due diligence to protect whatever asset you have. The fourth would be to enforce. Enforcement deals with basically scavenging the market to check if there are any competitors or any copycats who are trying to copy whatever you already have. So the intellectual property filing levels, there are few filing levels. Most proprietors choose to start on a national level. By this, if you are all Kenyans, some Kenyans tend to start with the Kenyan jurisdiction, which will be filing at either QP, Kekobo, or KEFIS. Then they will move to the regional sect. By the regional sect, obviously, we are speaking about the African continent. Are we okay up to that point? We are good. Have I lost anyone? Yes?
My name is Israel. Hi everyone. So I have a question. You told me, okay, I'm not me, because in the past, that there are bodies that actually govern the IP space in different regions.
Yeah.
So would it mean that it's possible for me to have an invention that will actually work within a certain geo space, and also and like not work in other areas because we have an existing one in another area.
Yes, so intellectual property rights are territorial in nature. So if you choose to register your intellectual property rights in Kenya, ideally it will only be protected in Kenya. If you choose to move in the regional set, I can go with OAPI. If you move to OAPI, the only countries which will be covered are the countries which are signatories to the establishing agreement to the OAPI organization is the Banjul Protocol. So all countries which are signatories to the Banjul Protocol will be applicable if you choose to move under OAPI. If you choose to move under WIPO, every country which is party to the Madrid Agreement will be applicable to whatever sect you want to move. Is that understood, Laura?
I'm getting there.
Yeah.
So what about now the example I'm actually like Z-Fast on Facebook. I believe I'm having that it has its own IP in the States, if I'm not wrong.
Facebook has its registered IP all over the world.
All over the world.
When you check, ideally, their IP rights are very. You can look at their trademarks. Ideally, the first trademark of of Facebook was registered in 2004. The first renewal was in 2014. The second, basically, 2024. So it's still running. Every country in which Facebook is operational has a protected IP right.
So to me, it's being like deployed in every particular area that can be used, right?
Yeah, whenever you want to deploy it, I can use a practical example. If you have a product which is launched in Kenya and you want to deploy it to Uganda, ideally the first thing which you need to do is protect the trademark in Uganda before launching the product there.
So it's possible for me to like deploy maybe the invention like worldwide, and only knowing that the world that actually like govern those rights. Let's now ask a form. Let's call it I don't know, microphone or something. So if let's say I want to like have rights of this phone like worldwide, then I have to have like an agreement with the bodies that actually are there to like have that patent over there as well.
It's not an agreement, you just file an application and it's registered. We're registering via internationally. We're registering via WIPO, it will be designated to the countries which are signatories to WIPO. Yeah. Okay. So let's do a quick overview of the IP rights. So for proprietors, you need to understand why each IP right is basically applicable to you. If you're dealing with your brand, basically it will be a trademark. If you're dealing with new inventions, it will be patents and utility models. If you're dealing with designs, it will be industrial designs. If you're dealing with creations, it will be copyrights. And if it's for specialties, it will be trade secrets and plant breeders' rights. So we'll move into each. We'll start with trademarks. So a trademark is a distinctive sign which is used to distinguish the goods of one entity from those of another. When you're looking at trademarks, you can look at the logo. Therefore, you can look at this CM Advocates logo. That's a trademark. Where else? The Apple trademark. This is a trademark. What else? This is a trademark. Basically, anything that distinguishes your goods from those of others in the market, that's a trademark. So a trademark can be a slogan, device, brand, heading, label, ticket, name, ideally anything. And it can be either 2D or 3D. So for our car lovers around, how many logos can someone, how many people are car lovers here? Anyone? I'm expecting a few hands from a certain type of gender. Can I pick someone or someone can just volunteer themselves? Okay, you. How many can you identify from this slide? Maybe we can start from the far. This is right.
Good evening, my name is Andrew Makuru. Thank you for having me. And I can identify at least, actually all of them.
All.
Yeah.
They are fairly easy. Can you can you state them?
BMW from top left.
Yeah.
Is Mercedes-Benz,
Uh-huh.
Porsche, we have Audi, then Hyundai, Ford Motors, Toyota, and Lexus, which stands for luxury exports to the US. We have Volkswagen and Honda, then Nissan.
So, yeah. Thank you for that. What's your name? Andrew. You should have come with a pen and paper so that you get to him and refer to you every single time. Now, Andrew. Let's move on. Now, why ideally do you think he was able to identify all those logos? Because we know the brands. That's the purpose of a trademark, brand recognition and brand protection. The second reason why you should register your trademark is that it gives you exclusive rights. Ideally, any other competitor in the market cannot use any of the logos, which have just been stated here. And then enforcement power, in the case of infringers or copycats, you can always move forward to institute a claim against each one of them, and commercial flexibility. By commercial flexibility, I mean that you can utilize your trademarks for licensing, sale, joint ventures, for whatever reason which you need to increase the valuation of your company. So the validity period of a trademark is 10 years, and it's renewable every 10 years, so the protection period is indefinite. So the registration process for trademarks, we will ideally start with a search. The purpose of conducting a search is to identify any trademarks which may be conflicting with their own on registration. So once you confirm that the trademark is available for registration, you'll move forward to filing. And on filing, the trademark will be subject to examination. So it will be examined for both formality and substantive needs. For formality, it will basically delve into the requirements for filing, like the application, the power of attorney, the whatnots, and then for substantive, it will deal with the actual substance of the trademark. We'll deal with the substance of each trademark in the next slide, and then it will move into the advertisement period. The purpose for advertisement is to inform the other people in the public that this is the trademark that you want to put out in the market. So it will be advertised for a period of 60 days, by which any party who is opposed to the registration of the trademark will file an opposition at keeping. And then on registration, a certificate will be issued, an original certificate. The requirements for registration. So the first thing would be distinctiveness. For the people with brands, it should be in line with public order and morality. Basically, it should not be offensive. That word is not offensive. The free legal advice disclaimer was for one person, but you can now go to the next question also.
Thank you. My name is Matthew. I have a question regarding non-deceptive and non-descriptive in terms of language. For example, if you were to use a local language to describe your product, so in this case, if I was to say I'm selling sweets, but then I use the word tamu, you know the way kids call sweet tamu, so does that apply? Is it limited to the English language, or does it apply when you use a word that means something in another language?
First of all, whenever you file a trademark which is in another country, the registry will always ask you to do a translation of that word. So if it's a word which they won't understand, they will ask for translation. If you do not provide it, it won't be registered. Secondly, tamu won't be registered just because tamu, first of all, is a common word. You cannot register whatever is already being used by every other person and claim it as your own. The second thing is tamu is very descriptive. You cannot, it's like I cannot describe this chair kitty and then go and register it as kitty. You see, I cannot.
Okay, so just to now follow up on that is now there's this way you coin a phrase, like you say, Kenyan fudge. So just using the examples you've given, so I can say kitty designs, or I can talk about tamu creations. So where you now combine, so does that combination then help you meet that criteria for descriptive?
When you add another word, ideally they usually say even if you have two non-descriptive words, if you put them together, they become distinctive. So in this case, you'll be asked. There's something called a disclaimer. A disclaimer is used for words which are common in trade. Whenever you are using words which are common in trade, you'll be asked to disclaim the right to the exclusive ownership of that word. So ideally, the word taboo itself, you won't have ownership to the word taboo, but taboo designs will be your own. Yeah. I hope you're okay. Okay. One more, then we move forward because we're a bit late.
All right, good evening once again. My question to you is, recently, earlier this year, I'm the director founder of an entertainment service provider. I titled it, or rather registered it with the BRS as Drewport. Not necessarily my name, DREW, DRUE, and PROD. So my question to you is that registerable as a trademark for one case so that it can be protected in that in case anyone would like to use a similar terminology to describe service provision rather than it being goods?
Ideally, it would be.
Yeah.
The only caveat to that is there's another person who came before you with that name. That's the only caveat to that. But if you are the first, then it's yours.
Okay, so it stands as registered with us.
Yeah, it stands as, yeah.
For registering services rather than goods. Because there's a very thin line.
You can register either services or goods. Because we have, I'm trying to find a simpler way to put it. We have 44 classes of goods under which you can, goods and services under which you can register your trademarks. So you can pick from the 44. I think it would be better to consult a professional to help you pick out the goods under each class, and then you can move on to register it.
Thank you.
So there's a case study on M-COPA and M-COPO. We can already see these two words are very similar. We all know what M-COPA is. So the major problem was basically the registration of similar trademarks. When you're looking at the similarity of trademarks, we look at it at threefold. We look at the visual aspect, we look at the oral aspect, and we look at the conceptual aspect. When you look at the three, obviously M-COPO and M-COPA are the same. So the judge actually ruled in favor of M-COPA, and this the name of M-COPA was struck out from the register. Is that okay up to that? Another case study will be for Sony Corporation. So the problem with Sony in this case, it had not registered its mark in Kenya. So it relied on, there's a principle which you use whenever you've not registered your mark in Kenya. But the thing is, your trademark has to be well known. By well known, it means that it must be known by a majority. When I say Sony, I'm sure 99% of the people here know what Sony is. So any other corporation which comes and tries to leverage on the reputation which Sony has cannot register its mark. That is the same case here. And the standard of proof of proving that a mark is well known is actually higher. You'll have to provide sales data, advertising evidence, media coverage, consumer research, and enforcement history so that you succeed in such a case. So my advice with this case, instead of going through the longer route, because for most SMEs and MSMEs, ideally your trademark will not be known by a majority of the public. So relying on this will be a bit harder. So it's easier to register your trademark just to prevent the enforcement part of it. We'll move to patents. The purpose of registering patents is to basically protect new inventions. There are three conditions of registering patents. The first is novelty. So you should ensure that your patent is new. What do I mean by new? It should not be released to the public. It should not be disclosed to the public in any form, be it be via news, via publication, even in a conference. You should not disclose your patent. And then the next is it should be an inventive step. By having it as an inventive step, you mean that a person who's skilled in that craft which you're working with will not ideally come up with the idea which you have come up with. And then the third will be industrial applicability. So ideally, whatever you're bringing forth should be able to be applied in the industry which you want to delve into. So the period of protection of patents is 20 years, and this period is non-renewable. So a quick exercise. We can start with the foldable phone. We've all seen it. The first to launch it was actually Samsung. Samsung? Yeah, it was Samsung. So ideally, do you think it is patentable? Whatever they launched. The foldable smartphone. Anyone? It is. Reason for that? Novelty. We'll come back to this. The conditions for patent protection. Novelty. It must be an inventive style, and it must have industrial applicability. The second will be that recipe you usually use at home. The one which you have, your grandmother taught you for. Do you think that's patentable? Anyone? 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 Susan, do you think it's patentable? Ideally, it's not, because there's not, okay. I don't want to say there's nothing new about it, but ideally there's nothing new about a recipe. Unless, I don't know, it may be one of those families, I don't know. The third would be a fitness tracking app. For the fitness enthusiasts, do you think if someone comes up with an app, it will be patentable? Yeah? Hold it. No, it won't. What's the reason for that? Yeah. Our favorite student over there.
I don't think it's patentable because fitness is something universal. Anyone and everyone can and will do it if they put the right to it. So having the application tracking is a set of what's already that exist by different organizations, different startups, different founders. So fitness tracking I do not think can be patentable.
Yeah, you're right. You're right. But my answer would be it depends. The answer is it depends. Ah.
I think it would be patentable because basically invention. But like right now we're living in a situation where the world is making new invention, and there's always something new that we have to find in order to innovation. Or goes up something to actually create a solution for. So I think if I created something at the intersection of opportunities, it's already available right now, created something new, then I definitely need to see that as a part.
You're right, a student. So, as if you're going to launch an app and it just contains information, basically that's not patentable. But if you come up with a new technical feature which will be included in the app, then you can patent it. It doesn't matter, as long as it has a new technical feature. It must be industrially applicable, then you can patent it. There's no one way to doing these things. There are certain things which are exempted from patent protection. This is provided under Section 26 of the Industrial Property Act, Cap 509. These include discoveries, scientific theories, and mathematical methods, methods for treating bodies or making medical diagnoses, plant varieties, inventions contrary to public order or morality, and schemes for business, mental games, or playing strategies. So if you have any of these or have the idea of doing any of these, just know it's not patented. I thought someone spoke, but let me please. The patent registration process. The first step will be to conduct a search. The purpose for conducting a search is to confirm whether there's any prior acts. Once you've confirmed that there's no prior act on the register, we'll move on to file your application. After filing the application, it will be published in the Kenyan Gazette for a period of 60 days, after which it will move to examination. The purpose of examination is to confirm the industrial applicability of the patent. Once this is confirmed, a grant will be issued and a certificate of grant will also be given to you. This will still be an original certificate. We have an interesting case here for Apple versus Samsung. For the tech enthusiasts, I'm sure you saw this. So Apple sued Samsung for copying its patent in 2011. So ideally, the jury initially awarded 1 billion in damages, but on review, Apple was awarded 539 million. The major patents in question was the tap to zoom feature in the iPhone. It was copied by Samsung. For the people with Samsung phones, you can check. You have that feature right now. I'm sure you have it. You can just, you can do something of the sort. It's there. So you can see the cost of infringement of patents. It's a bit higher. For industrial designs, the purpose of registering industrial designs is to basically protect the aesthetic features of your products. So it may either be in 2D or 3D also. The validity period of industrial designs is 15 years, which is divided into an initial 5 years, which is renewable for two consecutive periods of 5 years each. So the registration requirements will basically be novelty, which I've already discussed, public morality and order, which I've already discussed, and the exemption of pure artistic creations. So this exemption would basically be handled under copyrights, just because industrial designs deal with the aesthetic feature of a product. For the process of registration, it's still the same. It's a search, application, examination, advertisement, and registration. We'll move to utility models. Utility models still protect new inventions. So the difference between a utility model and a patent. So ideally, when you have a new process of doing something, but it's not ideally the first thought which has been brought out. Ideally, nothing is new under the sun. So if you notice or you got inspiration from a new invention, you can always register it under utility models, just because patents have a very high criteria of registration. Whenever you deem your invention not to fit into the ideal scenario of patentability or the requirements of patentability, you'd ideally register a utility model. So the conditions of registration are the same: industrial applicability, novelty, and it must be an inventive step. The period of validity of a utility model is 10 years, and this period is non-renewable. We'll move to copyrights. There was an artist somewhere, I do not remember. I hope you have registered your original works, wherever you are. I don't remember you. But basically, a copyright is meant to protect the original works of a creator or author. So the validity period of a copyright is 50 years. Depending on the type of copyright, the 50 years starts running from the time of creation. If you're dealing with literary works, musical works, dramatic works, artistic works, the 50 years starts running once the author dies. When you're dealing with joint authorship, that's the ownership of a copyright by two people. The 50 years will run from the death of the last surviving author. If it's an audiovisual work, these 50 years will run from the date that the publication was first made available to the public. If you're dealing with a sound recording, these 50 years will run from when the recording was made. If you're dealing with broadcast, it will run from when the broadcast first took place. So what can be copyrighted? We are going to look at the nitty-gritties of what can be copyrighted. The reason for this is Kenya operates a closed list of what can be copyrighted. So if your invention or if your original works does not fall within this list, ideally it cannot be protected as a copyright. So for literary works, it will be novels, poems, plays, reference works, newspapers, articles, computer programs, and databases. Artistic works, it will be paintings, drawings, sculptures, basically anything artistic. Broadcasts, the work which is basically broadcasted. For sound recordings with songs, spoken words, sounds, and other recordings. For audiovisuals, television, programs, movies, and the likes. Dramatic works is basically anything which is based on drama. So a quick quiz. I'm hoping the audience is familiar with these characters. So, ideally, who knows which of these has already entered the public domain? By the public domain, you remember the 50 years validity period I was talking about. So once the 50 years lapses, it enters into the public domain, and any person in the public can use that copyright to either resell, they can basically use the copyright in whatever way they please. So which of these enter the public domain? You can actually, for context, you can know which one entered the public domain by knowing when it was released. Like Godzilla, the original version, when was it released? Anyone who knows? Okay, no one is a baby boomer here. Oh, actually, no one is a baby boomer. So Godzilla was Godzilla was released in the late, it's in the early 1900s actually. So basically that's in the public domain. Sherlock Holmes, the first or the original Sherlock Holmes was released in the early 1900s also. Superman was released in 1974 if I'm not wrong. Plus 50 years. Is it 1974 or 1984? 74. The film itself. For the film itself. So, and then Batman was released, it's in the late 1900s. I know Batman is no, it's not in the public domain, it's still protectable. So ideally, that's how you calculate the period. Look at when it was first released. So the requirements for copyright protection, the first is originality. The work should be original. Like, it should not be based on any other person's work. And then fixation in a tangible form. You should ensure that whatever copyright you want to protect can be treated in a tangible format. And then statutory eligibility, this is what I was talking about. Whatever you want to register must be within whatever is provided for in the Copyrights Act, Cap 130, and then human authorship. Our Copyright Act is very strict on the requirement of human authorship. So even if you're using AI, make sure you've used enough human effort to create your copyright. You cannot base the registration of a copyright on purely AI-generated works. This is based on this case, area movement. It's a recent case, so I'm sure most of us, the people who are conversant with pop, we are aware of this case of PUNIT versus KCB. So KCB PUNIT sued KCB because of the use of the word weka weka in their art. So I'd thought that they'd win this case, but basically what the court says is the word weka weka is not original. Yeah, it's a Kenyan word. It's just a Kenyan word. There's nothing original about it. So their use of the word weka weka is basically like using the word tabu tabu. There's no difference.
What if it's a combination like weka weka finance?
If they use the lyrics the lyrics, the same intonations of the song, like the same arrangement of the words, ideally that would be outright copyright infringement. Is that okay? Can I move forward? Then plant breeders' rights. This protects new plant varieties for the people who do that. I'm not sure they're here. I don't think so. So 20 years, the validity period is 20 years from the date of grant. For trees and vines, it's 25 years. So the conditions for registrations are basically the DUS. Your plant variety must be distinct, it must be uniform, and it must be stable for obvious reasons. It's a plant variety. For trade secrets, there are a couple of people who have done NDAs. I'm not sure why. I'm not sure if it's because of employment, but if it's because of gaining a competitive advantage, that is a trade secret. Trade secrets are not ideally registered under any authority. This is your personal responsibility. Trade secrets is basically that secret that you keep based on the product that you have. A good example which you'll be told about is Coca-Cola. You're told that there's a specific thing they use in making of that beverage. I don't know it, no one knows it, but it gives them a competitive advantage. So the key features of a trade secret is basically confidentiality. Ideally, no other person in the public should know this business information that gives you a competitive advantage. It should have economic value. Basically, we've seen what Coca-Cola has done with that small ingredient they have. There should be reasonable protection measures. This will be by NDAs or even encryption of whatever data you have based on that information. So the validity period of a trade secret is as long as it remains confidential, not easily ascertainable, and provides a business with a competitive advantage. Up to that point, do you have any questions? Because we are in. Oh, okay.
Yes, so my name is Paul. My question is a few slides back when we discussing packaging. You have mentioned grounds for things that qualify. I'm curious to know whether vaccines count as something that can be packaged. So yeah, my thoughts, not to like levels of treating and stuff. Does that do vaccines count?
And a Kenyan law. The reason why vaccines, which vaccines? I went into COVID-19. Maybe you thought of something else.
Yeah, well, like polio, I think the polio vaccine is famous for that. Like, the one invented it for not allowing it to be patented, so it can be used by
the reason why such inventions are not patented is because it's meant for the public good. Especially when you're dealing with some things which deal with public health, ideally, that will not be patented. That's the reason the people who came up with the COVID vaccine will not keep it to themselves. They had to share it out. That's why you have Moderna, AstraZeneca, which one else? Those ones. That's the reason for that.
Hi.
Hi.
My name is Michael. I want to ask you, there is a software that I wanted to create a software. That software has, some people use Facebook, it has the code, then it has the logo itself. So now, how am I supposed to protect it? Am I supposed to protect it with the trademark, or am I supposed to protect it with the copyright? Because I've seen the copyright one of the eligibility requirements, digital markets, computer programs. So how do you go about that? Should I do, is it
let me use this example. See, you have this phone. We have so many IP rights protected under this. The first will be this, the trademark, this logo. The second will be this, the positioning of the cameras and industrial design. Just the swipe up, this is patented because Samsung does not have this or any other. So you see, you can use so many IP rights to protect one product. It's not limited. The last question, and then we move quickly. Here, or okay. Any, it's fine.
Okay, I'll repeat. I have like, and is it 2 or 3 questions? I can find other ones when we start. Can you have like a patent on a method of production? Let's say now they're like tabled, but then you have a patent on the method in which you yourself have, I don't know, curated or invented for yourself. So that's the first question. The second question is in tech, and like usually a thin line in regards to like inventions. Like let's say in fintech now, maybe one company uses like this technology, like they don't use technology. So how thin can the line be? Because now it's almost like they're just around the same area, but then it's a small like tweak or a part of here, yeah, just to see whether or not there's a difference between okay now, like this company A has this particular patent. My third question is on it's also like also patent, like a collection of like different inventions. And okay, somebody say I have a picture right now. That is a good bit, and this with this is all and another particular platform. And we are creating a whole other platform. It's not actually it's new, but then just try to just put this one together, and I can see your solution. So
So ideally, if I'm not sure about the industry applicable, I'll start with the third one. But if it's new, depending on your assessment of the industry, ideally it should be patentable. For the second one, whenever there's a thin line, I'd advise to register a utility model because of the patentability requirement, which is very high. So for the first one, yes, you can register methods. It must meet the threefold requirement. It must be an invent itself, it should be novel, it should have industrial applicability. Then it can be registrable. So
how like Google has its own algorithm on such. So there is I think it's model or a part or this because now it's like I think but I can understand that it's also an associated with issues or the secret and also model and
ideally, I think I can best advise you once I get the description of the actual invention. Because I know Google goes for patents. Google, Apple, they go for patents direct. If you know it's new, just go for the patent. Yeah, a summary of everything we've done. So for trademarks, basically we are registering our brands under marks, slogans, devices, and brands. The validity period is 10 years. For patents, we register the new ways of basically new ways of dealing with different things, and the validity period is 20 years. For industrial designs, we register the visual and aesthetic features of a product. The validity period is basically 15 years, divided into 3 parts, as I'd said. For utility model, we register the new and useful form of a product, which enhances functionality. The validity period is 10 years. For copyrights, we register original works. The validity period is 50 years, dependent on the type of works. For plant breeder rights, we register plant varieties. The validity period is 20 years and 25 for trees and vines. And for trade secrets, we basically protect the confidential business information which you have, and the validity period is indefinite. So, yeah, we'd move on to the next session, and I'd invite Nancy to do a bit of something. So, do you?
So, because I know you guys are boiling so much information. And carefully, I'm still learning you. So please stand up. Let's do a small stretch. Some quick holds up. Thank you for your instructions. Now we're going to get into a small game. It's going to be war. We're going to get into groups, so I need you to prepare for war, okay? Are you ready for war? Okay, let's go. Let's use it one, please. Follow my instructions. Let's put your right hand out and stretch it over your body. Do you feel nice? The hands are both cracking. It's not looking nice, huh? Alright, let's put our other hand out. Stretch it over our body. Oh yeah, those are my bones cracking. Did you hear that? Man, who's saying yes? Some of that's good. Alright, you can put your hand over your head. Now just do this to your neck. The other side, let's do the same on the other side. As you're doing that, for anyone who's come late, here's the Wi-Fi password. It's going to be very important for the next portion of the session. Does everyone have the Wi-Fi? It's giving I have a B. Okay, got you. A rich folks. So now I'll need you guys to get into groups of 4 with the people around you. Right now. This instant. Make friends. Please get into groups of 4 because we are going to be joining Slido. If you're unfamiliar with Slido, it's a question game. And so in your groups of 4, I need you to come up with a team name. Start socializing. People's names are on the gesture area. So if somebody is refusing to join your group, call them out. So I need you guys to come up with a group name and scan the QR code and join Slido. If you are unable to scan the QR code, thank you for coming. And welcome to Anna. If you are unable to scan the QR code, you should be able to join it with the code that will be displayed shortly. In the meantime, get to know each other. What does the person next to you do? Are they an innovator? Are they lawyers? Ooh, okay, great. Let's see how creative you are with your names. So I'm expecting to see 1, 2. Is this a group? I'll take it for group 2, 3, 4, 5, 6 groups. So I need to see people joining the quiz. Please scan the QR code or go to slido.com and add this code. So there's a group called Richard. Thank you, Richard. Group Richard Karibuni Sana. Did you guys just choose a team name? You say Richard is our master. Are you agree? You chose for them. You know we like a certain people. We stand by you. 5 more groups. Name 5 more groups. Just choose one person in your group to scan the QR code. That will be your representative. The person you think is the fastest winners. Okay, Team Andrew. I like the shooting names of people's names. I love it. Okay, Team Pattern. So let's go creativity. We're going to pattern that one. That's you guys. Yes, lock it. Alright, let's go, Lauren and Jano. Am I pronouncing it correctly? Will copyright that. Next group. Can we have our next group? Okay, Romanian. What is that? Who are those? Where are Romanian? Can you give us name? I everybody on? If you're represented, please say yes. Sorry? Not each person, each group. Alright. Maestro, let's go to the first question. You will have 15 seconds to answer. What does the abbreviation IP stand for in the business and legal world? I think it's investment plan. So if you trust me, choose investment plan. Survey says intellectual property. Okay, maybe it was in the title. Let's see what people choose. A lot of people choose, and the correct answer is intellectual property. Who was the fastest? Let's go for that. Woo! Give it up for yourself. Let's go. Let's go. So they are the fastest figures. Let's go to the next question. True or false? The country of South Africa has 3 official capital cities. Yo, I know. That's how South African. Is it true? Is it false? Do I know the capital cities of South Africa? Somebody says true. There's somebody saying false. Right. I heard you so much. The answer is true. Let's see whose answer is. Piloting. Let's go. But it's been like not to the picture. Right. Let's go. They're coming for their crown. Not because it's true. Which are the capital cities of South Africa? He said Cape Town, Joburg, and Pretoria. I know what Jay didn't know. Sorry, where's the Jay? I can't. I'm sorry, yes, Next question. Okay, which is the correct spelling for the term used when somebody uses your IP without permission? Let's see who gets Nazareth. I liked this one in Nazareth because I don't know about you guys. First, let's see which is the correct answer. Yo, some people said it's the first one, some people said it's the second one, and the correct answer is the second one. Does somebody need to go up to Nazareth? I don't know which one you are. Let's see who the fastest. Again, Panatech. Someone be shy. I thought you were taking the crown. Team Arthur, what's going on? What's going on? Who's this? Who's representing? Team Arthur, I was like, I'm so happy for everyone. Let's go to the next question. How many days are there that started not here? 365, 366, 365, 375. Personally, I think it's 366. Trust me at your own risk. Higher. Somebody said 365, okay. 14% said 366. Who has ever been there for 0.75 day? Personally, I've never experienced a 0.75 day. But I'm not judging you. Let's see what the real answer is. 365. Let's go. Who had the fastest fingers? Richard. I knew you were coming for them. Quadri, guys, what's happening? What's not happening? Andrew, good effort. Team Andrew, we see you. We validate you. Next question. And this is the final question. For the cup, if you create a logo for your company, the logo itself is protected primarily by copyright. You're just removing this. Is it true or false? She literally just talked about it. Somebody said true. Mnapeana leakage. Ooh, 29% said true, 71% said false. And the answer is true. Whoever sets the questions is a liar. The lawyers said it's false. It's a trademark, it's not a copyright. I definitely knew this when I was setting the questions. This is why I'm in class as well. But assuming it was true, which team got it right? Which team is at the top? Let's go patented. What a twist. Let's go patented. I'm shocked. Patented, you were on the lead. Congratulations, patented. You get the crown. Where's patented? Where's team patented? Yay! A round of applause. have been seen. Somebody says you stole the last point, and I don't know who they are. Let them fight themselves, right? Oh my God, you guys, you're so tough. Let them even fight themselves. Okay, thank you so much for participating. Let's have our seats, and then we'll welcome Massive back to the stage to the next part of the session. I hope you're feeling energized. I hope you're feeling relaxed and ready for the next session. For anyone who wasn't there when we started, again, my name is Nancy Uhuru. I promise you I'm not a random person on stage. I am actually a part of the iHub team. iHub is a CC Hub company, and what we mean by that is we have presence in 4 countries across Africa. That's Nigeria, Kenya, Rwanda, and Namibia, and we are now setting up a hub in Togo. So the work we do goes across 3 focus areas. That's the creators, people in health, and finally, people in the education sector. So how we support them is, one, we have multiple accelerators, multiple incubators, we have co-working spaces for people in business, we have podcast studios, we have editing suits for creators, and so much more. Honestly, if you'd love to learn more about iHub, I'd be happy to support you in joining the community. Later, we will have our newsletter scrolling around if you want to keep up with what's going on in iHub and the general ecosystem. We have a WhatsApp channel, and you guys will be the first to join the WhatsApp channel. It's brand new, it's literally 1 day old. I did it for you guys. You guys, it's for you guys, yeah? So when you join our WhatsApp channel, you'll be able to also keep up with other things going on in the space. So back to Mercy. There you go. Okay. So we'll move into the money bit of IP. So if you have registered your IP, there are different ways of commercializing your intellectual property rights. Commercialization basically means the turning of your assets into revenue. So there are different ways, which will be by either sale, assignments, licensing, spin-offs. We'll deal with each in the next slide. So when you're dealing with licensing is basically giving a bit of your rights to another party in exchange for royalties or fees. We've seen this in various areas. We saw it in 2011 when Apple and Nokia, when Apple gave part of its rights to Nokia, we saw it. Anyone remember? Okay. Crickets. Okay, so basically licensing is giving out part of your IP rights to another person in exchange for royalties. The second will be sale and assignment. This is the total transfer of ownership of your IP to another entity. This is done basically when you're dealing with mergers and acquisitions mainly. When you're being acquired by another company, ideally you transfer all the property rights to another entity, obviously, to the acquiring entity. And then for joint ventures are basically vehicles that lead to a specific purpose. So ideally, let's say if the purpose would be to, let's say, market. You'd partner with a marketing firm. The marketing firm would get some type of rights to your IP rights, to the use of your IP rights, and they use your IP rights in marketing. That's what a joint venture is. The closest example I can think of is when Moderna and BioNTech, they partnered to come up with the COVID vaccine. I hope someone saw that. I hope. That was one of the most known joint ventures. And then for franchising, we've seen it with KFC, we've seen it with Starbucks. So basically, it's giving out of your IP rights or even your brand to another organization for use. We've seen it. I'm looking for another trend. Any other company which you can think of? Sorry? Shell.
Yes, Shell. Yes, Shell. Especially when you pay via Shell, I'm sure you know, you've seen the company which pops up. It's not the original Shell. That's franchising. It's basically using the brand which is used internationally and bringing it locally under the same brand. And then for spin-offs and startups, this is basically building your ventures around whatever new invention you have. You dealt with there's something, there's an invention which you came up with. So if you build your invention around that, that will be a spin-off. So it will be a way to raise money ideally. You will use that invention to raise money or capital for your own business. We've seen this with Dropbox. Dropbox used whatever invention. Basically, Dropbox started as an invention of some students at Harvard who wanted to get a system whereby you can obtain documents easily. So that's why they patented that invention which is used at Dropbox. And they centered the whole business around the sharing of documentation via Dropbox. Well understood? Okay. So what are the benefits of commercialization? It will be revenue generation. Ideally, if you deal with any of these, you'd automatically gain more revenue. And then market expansion. With the example of Shell, we can see that Shell expanded from an international level to those national levels in Kenya and any other country, and then you gain a competitive advantage. Shell did what, I don't want to use Rubies unless someone is affiliated with Rubies that's here. If Rubies were to venture out, they will basically venture out using franchising or any other way. And then innovation incentives, whatever you gain from the innovation, from the revenue which you get, can be used even in research and development. If you're dealing with pharmaceuticals or even the creation of new plant varieties, and then it also strengthens the brands. An example would be KFC. Okay, I'll speak for myself. I got to experience KFC once it came to Kenya. I knew the brand of KFC once it came to Kenya. And the reason why most Kenyans are actually affiliated or feel affiliated with KFC is because of this franchising agreement they had with this local company. I do not know the local company, but the best way to know the local company which deals with the franchising is to check the name which pops up once you pay. You just know this is the company which got the franchising deal. The next is collateralization. Collateralization, anyone who knows what that is? Anyone? Anyone who's ever taken a loan? That is collateralization. So right now under the MPSR, you can take a loan against your intellectual property rights. This is provided, the MPSR is the Movable Property Security Rights Act, which was enacted in 2017. So how it works, it would be basically through valuation first. Your IP rights will have to be valuated to determine the revenue which it will bring forth. And then registration, once your IP right is valued, it will be registered at the collateral registry. The third would be having a security agreement. Basically, the security agreement is between the lender and you. Basically, just to ascertain the rights between the two parties. And the last one would be monitoring to maintain all the IP rights which are already in force. As you've already seen, the different IP rights have a different validity period. For some of them, if you do not renew them, they are lapsed and they are removed from the register. So if you do not maintain it, basically you're losing all the IP rights which you own to that asset. The last will be the benefits of collateralization. It will be the access to credit. This is self-explanatory. And then innovation in the sense of the use of such credits in research and development. And then for portfolio leverage, you can use whatever you have in your portfolio to gain more revenue and even acquire more assets. So on a market note, NCBA introduced an IP-backed financing for Kenyan for Kenya's creative sector, allowing artists and IP-rich SMEs to use royalties and other intellectual property rights as collateral under the MPSR. This was launched last month for any creative, there was a creative at this end, for any creative who has registered rights who seeks to leverage or use the IP rights as collateral. You may get a loan based on whatever you've already registered. Keyword registration. No bank wants to deal with unsecured property registration. So let's look at the emerging issues in intellectual property. The first will be digital transformation and intellectual property for AI-generated works. As I'd already stated, especially with copyrights, anything that is purely AI-generated cannot be registered and it cannot be protected. You may use it as a tool, but a tool will never replace a human. That's understood? It's a very critical point, which is there's an ongoing debate around this all over the world. We've seen it in various cases. We saw it with the Getty Images case. We saw it with the even Westlaw case. So it's very important to establish what actually works. And then for training data, so data scraping is not illegal, it's allowed. The thing is you cannot data scrape whatever is already protected. An example will be you cannot data scrape a whole book and claim like it was in the internet. Now I can use it. As long as it is protected, you cannot data scrape whatever is already there. You can use whatever data is already available publicly to train whatever LLMs you have, but still make sure you are not using protected works. And then for software design, there was a question on using different modes of IP. So when you're dealing with software, there's a convergence between copyright, utility models, and even patents. It is fine to merge the three. You'll get the full protection experience. The major thing is to make sure that you leverage all your you leverage IP rights in the protection of whatever asset you're bringing forth. For globalization and cross-border intellectual property enforcement, ideally, I've indicated that intellectual property is very territorial. So you'd have to register in every jurisdiction which you want to get in. That is the major difficulty with IP. The other thing would be with the harmonization of laws. These laws are different. Whatever agreement we do today is based on Kenyan law. When you move to Uganda, the term of protection of trademarks is 7 years. In Kenya, it's 10 years. So you have to be very diligent and know the laws. The third would be data and trade secrets. So ideally, as long as you have an IP right, it's your responsibility to protect it. If you have a patent, okay, you've registered it, but obviously the technical components of the patents are not available to the public. It's your responsibility to take care of whatever technical features or whatever technical information which you have that will give you leverage. It's your own responsibility. We all know of the cybersecurity risks right now. So whatever method you use, encryption, anonymization, whatever you do, even an NDA, just to limit your employees from taking your own idea, use it. It's your own, it's for your own good. Are we good up to that point? Okay. So the key takeaways from this session, the first, IP is your asset. Most people lose out on whatever they actually created just because of not registering IP. A good example will be the Facebook story, which we all remember. The twins lost out on something which would have made them a billionaire, but it ended up making another person a billionaire. I hope we've learned from that. It was a 2004 case. May we not repeat it in 2025. And then the second step is to follow the cycle. Identify whatever innovation you have. Protect it, monetize it, and then enforce it. That's understood? The third step would be basically to just start now. As I've stated for you, I hope you are going to register your mark or your invention. Do not reveal it to the public unless you started there. initial steps, which is to identify which you have and then protect. Before that, do not tell it to anyone. Any other person in the room, make sure you start as soon as possible, even before you launch whatever you have. Ideally, if you have a product and it's new, or you have a new way of doing something and you launch it, there are a million people who can replicate whatever you have in seconds. So it's your responsibility to take care of it. Okay, we are in the Q&A section. I've seen questions. My colleague over there, Suzanne, will help me out with a couple of questions as I take a breather in some of the questions. But I'll take a majority of the questions, obviously. So let's start. Where's the mic? Oh.
Thank you. Great presentation. My first question goes to the Kenyan scenario. So there is a concern it's quite context that the act of going to register your whether it's a patent or trademark with the relevant bodies exposes you to individuals in pockets who can move faster than you. So what are some of the safeguards that are there currently that can help one in such scenarios where you may not have resources, for example, to proceed all the way with securing the invention as fast as someone else with deep pockets? Then secondly, maybe just advice on those of us with regional ambitions. If I was to, this example you give about doing something in Uganda, are we saying then that the first step, as now from an entrepreneurial point of view, is just to identify the types of safeguards that exist in the markets that you want to get into? And now, again, the next thing is how effective is that? Is that not just a waste of time and a waste of money? And then now, thirdly, is there a repository where we can have big players, usually what we call regional players, that can give some element of shielding or let's call it a level of protection, so to speak, or entry, level of entry into specific markets in the region. I can clarify that later. Let's start with the first one.
Okay, on the first question, thank you for the question. On the first question, whenever you file an application, you are not mandated to reveal everything. You are only mandated to reveal whatever is sufficient to secure your protection. Secondly, even if whatever you file, whenever you're doing a patent, there are a couple of things which are required. Will require the name, an abstract, the claims, the brief description of the invention, and the drawings if applicable. So whenever the patent is being advertised for that period of 60 days, the only thing which will be revealed is the name of the inventor, the address of the inventor, the drawings, and the name of the invention. That's it. Every other thing is not subject to public revelation, so it will not be revealed. The other thing, if you really want to protect your invention, whenever you're dealing with another party, any other party, make sure you have an NDA. Make sure you're walking around with an NDA somewhere. You just take it out for signature. Always have an NDA. For the second question, WIPO is currently offering an investor assistance program. So whenever you need assistance on subjects which you do not understand with regards to patentability, you can always apply. It's free. The only thing which you cater for are basically the disbursements and the government costs. WIPO is the... Do you know WIPO? You can search it below. Yeah. So what are the second question? Were they 2 or 3?
So, for example,
If I was to use an example of this guy in Zimbabwe who developed some technology for electric vehicles and not requiring the need of a battery. So then you hear that he got quite a bit of backlash from the international community, so his invention was suppressed. Locally here we have this guy who built a helicopter, the guy who built a helicopter, and then you find he got slapped with so many violations of public safety, public health, etc., etc. So that's what I'm referring to. Do we have bodies that apply or operate in a regional space or regional setting, in the case specifically for inventions, some physical inventions?
So when you're dealing with inventions, the major institute which usually administers inventions is the Kenya National Property Institute. So ideally, whenever you step into that space, whenever you go to the KIPI, they'll always help you out. The problem would be for the helicopter side, obviously there were safety hazards. There were permits which weren't procured. For the helicopter, I don't think it's new. For Zimbabwe, obviously, there are major factors which are involved, especially when you're dealing with clean energy. So obviously, there's a lot in that. We already know whatever happens in the climate change space. So yeah, that is that.
Yes, my name is Paul again. My question is just based on costs for all the patenting, trademarking, and copyright. I just wanted to ask, are there standard costs for each, or do they vary? What are the variants? What determines them?
The most expensive will be the patent for obvious reasons. The application period runs from 2 to 3 years, so ideally, there's a lot to do there. For the official fees, they vary through the IP rights. It will be the cheapest will be the copyright, the most expensive will be the patent. In between the other line there. The figures, you want the exact figures? Oh man, it's a lot. When you're dealing with a patent, the filing fees, the first will be the search fees. When you're filing the search fees for government is for a patent, it's 2050. Filing 3050. What is it called? Filing. The next will be examination. Examination 3050. Publication 3050 still. Examination 2050. Registration 5050. So at the total of that. And ideally, patent experts are not cheap.
Good evening once again. My question to you is regarding, I'm looking to venture into voice acting as a profession, and I would like to understand the proper legal steps that I should take so that my craft or my voice is not ideally used for manners that I haven't set to, or rather agreed to. And this is stemming from a conversation I had with an individual on the Copyright Tribunal of Kenya last week. So I'd like to understand a different perspective as well. Thank you.
I didn't know the basis of that conversation. Was it Wilfred? Who was it? Was it Liz Leto? Okay, what did she say? She's my senior, so I'd like to know.
She guided me to ideally go for proper legal representation, as well as trying to have a set of work that you've already done previously and copyright it, or rather just make sure you have the legal certification proving that it is you who created it.
She's very right. What Liz usually affirms is having evidentiary documents. The only way you can have evidence is if you protect it. So ideally, if you are a voice actor, that will be a sound recording. Basically, it's within that respect. So yeah, registration. What I'm wondering is how would you put this into a tangible format? That is what I'm wondering.
That's what I'm curious about.
Maybe you can take a recording of whatever you've already done, project it, obviously. That's around a sound recording. That's 550. You can do it yourself even. It's a very fast process. You can even check it. You can register it via Kegogo. Take that sound recording, make sure it's in a tangible format. Upload it to the website, then it will be protected automatically. So the other problem would be as much as the sound recording is protectable, your voice as it is cannot be protected. It's not provided under the Copyright Act 130, so unfortunately we are not there yet as a country, but you can still protect it as a sound recording.
This is also from the level of people, for purpose of an example, I'll give the example of Johnston Mwakazi. We also have Jeff Koinange, who are very, very well-known individuals from that craft.
I'm also thinking on the angle of the use of AI.
Yes, exactly.
There's a case currently on, who's this guy? This guy who's been called all in my life. What's his name? Morgan Freeman. Yeah, there's a case about the use of his voice. It's been used everywhere in AI-generated works. So we'll see how that pans out.
I'm just laughing about the Morgan Freeman joke. So my question is, when you, any of them, does it start protecting you the moment you apply after the search, or like when does it start protecting you? Because I'm thinking of it in a startup manner, where I cannot wait for 60 days or 3 years just to validate that I want to do the work, right? So when do I start doing the work and knowing that I'm getting protected as I continue innovating, and also the idea keeps changing as I work on it?
So the purpose of the search is just to ascertain that your work is new, just to ensure that when you file it, it won't be rejected by the registry. So once you confirm this, you file. So all the works will be protected on filing. As soon as you filed it, no other person can come and file it again. That's it. As long as it's stamped, signed, and you've been given an application number, make sure all of those are given. If you're not given an application number, you automatically know you're not in the system. If it's not been stamped, it's not in the office, no one received it.
I also am an associate practicing at CMS, but I just want to add. I want to add to that conversation, at what time does the protection start? Mercy is here to confirm that for copyright, the protection would be immediately after the work is published. So you might not have registered if it's copyright, because as she's presented, there are various forms of intellectual property rights. So I'm speaking particularly about copyrights. The protection starts immediately it's published. Yeah, so you do not need to register it. However, as she said, and the practitioner should usually advise for registration because it helps in evidence when there is contention about who owns the copyright. So the protection for copyright will start immediately publishing. So if it's a song, immediately you upload it on YouTube, then it should be protected, even without you necessarily filing it in Kobo. But we advise for registration because then it is hardcore evidence when there is contention about who owns what right.
I hope you're not too confused with that.
Right.
So the purpose for this is that the copyrights are protected on creation. So as soon as you create it, it is protected. The reason for this is because Kenya is a signatory to the Berne Convention, which provides for the immediate protection of copyrights and creation. This only applies to copyrights. Please do not try this with patents, utility models, or trademarks. It it only applies to copyrights. Any other question? Hello? Yes, I can. Okay, so my question was, in terms of my apologies that I did, and I don't need to take it back.
My question is, I didn't know all this, like this entire process of still copywriting and patenting, and I think now for me, I would fall under the one for brands, trademarking. But now the problem now is, how do I balance between, because I saw part of the the topics for the conversation was having that competitive advantage and preventing competitor theft of your idea. So I want to market what I'm doing. I want to market, quote unquote, my invention, but I also don't want competitors to steal it, as I'm still working on the registration process. So do you advise me to not have it out there, like completely not, like just withdraw? Like for me, I've already started. Do I now withdraw it back until I make sure everything is like protected? Or like, how do I navigate these things? Because as I market for the program, I need people to like join the program, and they can't join a program that they don't know what's happening in the program, right? So I need to tell them this is what, but the problem is that, again, I'm not a big fish. So if the big fishes see it again, they can just easily steal my idea and go with it. So navigating such.
The first thing would be, it should be protected or finally. You do not need to reach through the registration process. The second is, even if you withdraw it, the international marketplace, it's out there. So it's done. Fine immediately, ideally fine immediately. That's the only way you will prevent competitors from using whatever you have. Ideally, you have a duplicate of whatever you are doing if you do not register it. There's usually a small symbol of hash that shows that your trademark is registered. So as soon as it's registered, indicate clearly that symbol, put it against your trademark, so that every person who comes across your brand knows that it's registered and it's not subject to imitation or reproduction. I think
finish with two and
Thank you, MC Square. Thank you for the big energy. My question takes me a few years back. I completed my high school and I ventured into fashion as a model. And fast forward this year, I realized this designer was using our image. She commercialized our image outside the country and also in different malls around here in Kenya. But we never had such an agreement. And I've realized that is something she's still doing till date. So how can we help people who don't have this information, because they didn't have that information till this year?
so that's not a matter of IP, that's not a protection. You can actually receive a lot of money from that person that represents you. Whoever is using your image without your consent, and really get a lot of damages from you. You should give consent for the use of any image. So your image is defined under the Data Protection Act 2019 as biometric data. So whatever you give is yours.
Okay, thank you once again. So I'd like some specific examples of information that can be presented to an investor audience, specifically now targeting two different categories. One is the case of software products or tech products, and the second one now is hardware product, but leveraging robotics and a bit of AI. So just to provide a very simple example, let's assume I've made a smart dustbin that this is not from a project that I had, a friend of mine had way back in campus. So these smart dustbins that are in Japan that have an LCD display, it tells you what level of filling it has, is it full, is it partially empty. So now, given I like the question that was raised about preventing competitor theft, so now I want an example that is now targeting the an investor audience. So I'm here, I have my invention, whatever it is. What are the key things that need to be conveyed for you to have that, to give that confidence that you're actually on the right path? To spin off or build on her question is, you see, she says she may withdraw, right? It's already out there. So if I'm an investor, I'll be like, okay, you started, but you dropped the ball, you haven't completed the process. So that's now what I want, a specific example on what are the key things that must be there in order for you to at least have provide that confidence. Thanks.
Thank you for that. Remember the cycle for IP protection. You identify whatever you want to protect. And then check register. Before you even go to an investor. Why are you seeking funds when you not register? Whatever you have. Will your investor have confidence with you? Are you sure about your investor? Is he or she two-faced? Do you have an NDA? Did you sign a form of pre-trial questionnaire before you even got into the meeting? Those are the questions you're supposed to be asking yourself. If you have none of those, don't step into that one. I hope that answers you.
Okay, the answer is okay. I like it in terms of the questions, but now what I've picked, in short, is that the first thing is you need to have registered your invention. So that is step one. Then step two, there are those two things you've mentioned, like for example, that pre-trial form content thing. Yeah. Now my question is, in the case also of a startup, there are certain things that you may not have the luxury of time or even resources to do. So that's why I wanted now, for example, a very simple example that just captures the key things that need to be there. Because what she said is something I can resonate with in terms of I'm presenting my idea. Yes, I've registered, but is that registration sufficient to protect me now? So when I ask my question about players with pickpockets, so maybe in the case of the tech space, I'm building my MVP, my minimum viable product. So it has certain features that are still in development. Now, this investor, whoever it is I'm talking to, sees what I'm doing. We can very quickly iterate and actually roll out something that is complete, which is already what I was building. And then by the time I'm now coming in now to kind of like now protect my assets, I find, oh, okay, someone beat me to the game. So that's what I wanted. Like, so in terms of, maybe you can just give a very simple like walkthrough. So I like to read from the examples, step one, registration, step two, ETC.
Ideally, would I really know what you work with when you're entering into that room with investors? Yes. But the registration serves to prevent any other competitor or even any other person who seeks to benefit from your IP from even gaining leverage over you. The idea around IP is to protect whatever idea you have. It can only be protected once it's registered. So even if it's registered and they take your rights, it will be subject to infringement. You can always launch an infringement. So do you remember the first story? The twins and Mark. The twins launched the suits, claiming that whatever information Mark got gave them a competitive advantage. They were awarded 65 million because of that. Just have your cards right when you're entering into that room. Have your cards right. Make sure whatever IP you have is not just rudimental or in draft. Make sure it's registered. Whatever information you choose to take to them after that, again, you can give a brief description of your invention. The technical features are up to you. You can say that it says, does this and this and this.
whatever technical features that enables this product to perform a specific task are up to you. You do not have to reveal every information. Again, I insist on NDAs. NDAs, this is the purpose of NDAs. Yeah, I hope that's fine.
I think also, as you're mentioning, as you're stating the question, I'm thinking about the very recent case, I think it's Safaricom versus Infotech, where it's just the thing that you described. Infotech Innovations had wanted to do something, had approached Safaricom to develop for them, and it was an app. Then very quickly they found out that Safaricom had sidelined them. We went on to produce the M-Pesa business app. And I don't remember the other app, but when you look through the Safaricom app, you see those different variations of M-Pesa that are there. So they were claiming that actually they were in discussions with Safaricom to produce those for them as their developers. So I think that's a similar case. The final decision of that case is very somber, because there was an arbitration that had awarded $1 million, that had awarded the court $1 million, but it was later overturned. Why? Because the partnership agreement between Safaricom and Kokote initially, when they started the discussions, had not been signed. So there was a technicality that eventually led to Kokote losing on the $1 million payout. But also, even as we're thinking about IP, because I deal with corporate law, it is important, even as you enter into this NDA, to ensure that certain formalities are in place. Make sure that the NDA is signed, because why Kokote is losing out is because they sent a contract to Safaricom that was not signed. And that's they did not even go into addressing the substance of the IP law, just based on that technicality. Yeah. So I'm adding that because I practice corporate. And so ensure that you have counsel that is ensuring everything is proper, including the very things you think is really things, like make sure the contract is signed, the NDA, and also I insist on having NDAs. Because in this, as I was reading through that case, I was just worried, where was the NDA? They didn't have an NDA, they are just started laying out the entire plan, this is the app, this is how we're going to work, even giving them the source codes with no NDA, and I was a bit worried for them. So those also make 2 cents.
Thank you so much, Sue, Suzanne, and Marcy. A round of applause for the two. I don't know if this presentation is IP protected. Have I used it correctly? Again, I still have a long way to go, but thank you so much to them. So I was talking to 2 people at the back. One person said they're hungry, and I get it. We've been here for some time. We have tea. The other person said they have some really, really deep questions to ask the CM advocates. So I'll just have the CM advocates raise their hands so that if you have further questions for them, very specific questions. Can you just wave to the crowd? CM advocates, yes. All of them are wakils, lawyers as they are referred to. So again, if you have any questions, corporate law, what you've done, something a little bit more niche, some a secret, maybe a trade secret, please feel free to reach out to them. A big thank you to them for partnering with us. Again, another round of applause to them. Without them, a round of applause for yourselves for coming. Thank you so much. That's why appreciating yourselves. Love yourself more. A round of applause for yourself. Thank you so much for taking time to be here. For any inquiries, these are their contacts. Please take a photo. This is the time. The time is now. They have a phone number, an email, a website, and a physical location. I believe you can just pop in. They will be better, they'll get a better position to advise on that. And then finally, we have our I Have newsletter. If you're interested in such events or events, different kind of events, you have round tables, you have fireside chats.
Sometimes they're just networking events. We call them meet and mingles. You can join the newsletter. They'll be scrolling around. And finally, we have our iHub WhatsApp channel. It's a little bit faster if you really and truly you're not an email person. I get it. If you want to just get your updates quickly on the WhatsApp channel, scan the QR code, join our WhatsApp channel. Again, you're the pioneer group. You're the first guys to be joining this channel. So, you'll be getting first-hand information on what's going on. So now I want to release you to just go have a cup of coffee, have a snack. And thank you so much for coming. And I look forward to seeing you guys again for the next one. Asanteni sana. So please feel free to serve a cup of coffee.